very much, and please give us a warm welcome to Warren. He's going to be talking with us today about criminal trial processes and the need for reform. Thank you, Warren.
Thank you very much for the welcome and for the introduction. It's very nice to be here. Because I'm being filmed, I'll try and stay still. I'm naturally peripatetic when I'm talking, so I'll have to remember to be relatively still, and I'll stand so that you can see the screen, because I'll just sort of follow through the PowerPoints. What I'm going to do today is talk about some of the work that I did at the Law Commission in relation to criminal processes. Hence, the PowerPoint is on Law Commission slides. So the first disclaimer is that I no longer work at the Law Commission, and therefore the views that I'm going to express today, notwithstanding the fact that the slides are on Law Commission logo because it relates to their work, my views and not the Law Commission's views. The second introductory point that I wanted to really make right at the outset is that a lot of what I'm going to very briefly outline to you, really for the purposes of our having a discussion, are reforms that I think are needed to criminal processes, that a lot of those working in the system find to be anathema. And therefore they are reforms that are both controversial and in some respects, in terms of what I'm about to say, a little bit out there. But one of the things that I've found over many years doing reform is the importance of putting aside all of the things you've taken for granted about the way we do things, and think laterally. In other words, to question why we do things the way we do them, and to be open to different ways of doing things. And that's where a lot of this work has come from. So what I'm going to do is three things. I'm going to talk about what I see to be the problems with current criminal pre-trial processes, the way the criminal courts before trial, and to a lesser extent at trial, operate. Secondly, I'm going to talk about a number of the reforms that have been enacted by the Criminal Procedure Act 2011 but not yet in force, are designed to address some of those problems. And then finally, I'm going to talk about some of the proposals that the Law Commission put out in a discussion paper earlier this year that suggested that maybe we need to go further. So those are the three areas. So let me begin by just talking about the nature of the problem. And before I do, it's probably worth just stressing that what I'm not doing here is talking about changing the balance in terms of rights of defendants and rights of victims in the community. A great deal of the time, the debate in this area tends to be pitched in those terms. It tends to be pitched in terms of the fact that we place too much emphasis upon the rights of defendants, not enough emphasis upon the rights of victims and the needs of the community. We need to rebalance the system. That is not what I am talking about. Equally, I'm not talking about efficiency at the cost of justice. Again, whenever I talk to Defence Counsel about these sorts of issues, they see any attempts to streamline the system, to move cases through more quickly, as at least potentially at the expense of defendants' rights and at the expense of justice. When the Law Commission put out its first report on these issues back in 2007, we actually entitled our report Reforming Criminal Pretrial Processes, Justice Through Efficiency. And we deliberately chose that title to stress that actually justice delayed is justice denied. It is an old cliche, and I know it's banal, but it actually has an element of truth in it. If cases take a very long time to dispose of, it is not in the interests of justice or fairness for anyone, including actually defendants. so that we ought not to see these things like efficiency and effectiveness, rights of defendants and rights of victims as polar opposites. They're not. They need to actually be equally incorporated into what we're doing. So what's the nature of the problem? Well, the first problem that's really at the core of what we need to fix is that there is an entrenched culture of delay. People simply accept that it will take a long time to dispose of cases, and therefore it often does. There are a whole lot of unnecessary court appearances before the final disposal of many cases. Now, of course, there are quite a lot of cases that are disposed of at first or second appearance because people plead guilty early, particularly in minor cases, and we get rid of them. But for those that go further into the system, where there is an initial not guilty plea, they often go round and round through the system, making very slow progress with a great number of court appearances where very little happens. It is not uncommon for cases before final disposal to have 20, 25, 30 court appearances. The worst example that I have had given to me by a Crown prosecutor in Auckland is a case that had, before final disposal, 123 court appearances. Any system that works like that is actually fundamentally broken. And it is a system that needs to be reformed. Another element of the culture of delay is the large proportion of what's called cracked trials in the literature. That is, cases that have a not guilty plea, are set down for a defendant hearing before a judge alone or a jury trial, and then fall over either shortly before or on the day of the hearing, either because the defendant changes his or her plea, or because one or other of the witnesses don't turn up, or because the prosecution at the last minute withdraws or amends the charges, or whatever it is. That's a very substantial problem. It is not uncommon for the number of trials set down for hearing on a particular day, the proportion of trials set down on a particular day that go ahead is less than 25%. The rest of them fall over for one reason or another. And of course, all that creates enormous churn, because we have very large numbers of cases staying in the system for a long time. And that creates delays, and it creates complexity in scheduling. It obviously creates also duplication of effort because of the passage of time. Cases go on for so long that people have to keep on refreshing their memory as to what the case is about. Perhaps most importantly of all, it actually causes very poor utilisation of judge and courtroom time, and therefore very substantial cost to everyone. Because of so many trials falling over on the day of fixture, the way that the system attempts to deal with that is by overscheduling. So in cases before judges alone, what registrars do is routinely substantially overschedule the number of cases to be heard by guessing how many will fall over, so that you overschedule by 50-60%. You set down for trial on the day twice as many cases as you can hear or more. In jury trial cases, you cope with it by having backup trials. So if cases fall over, you can call everyone in at short notice. Now, in relation to judge-alone trials, the overscheduling, of course, because it's in case, inevitably creates unders and overs. Half the time you overschedule. You don't schedule enough cases, as a result of which it's all over by lunchtime. So I have frequently been in defended hearing courts in the district court before a judge alone, where the judge who's set down to hear the defended hearings for that day finishes at lunchtime. They may have other work for the afternoon, or they may go home and mow their lawns, which I'm sure doesn't happen very often, but I can certainly think of one occasion when it did. And that, of course, means that the courtroom sits idle for the afternoon. The judge who's set down to do that work isn't doing that work. Prosecutors go back to their offices. That's all an enormous waste of time. It simply adds to the delay. At the other extreme, cases will, of course, go ahead, or most of them do, as a result of which too many cases have been scheduled. What's the result of that? All the victims and witnesses and others come along to court to get evidence, they sit there all day, and they go home again. And they're told they will have to come back at some other time. Now, actually, that can happen with victims more than twice, let alone the witnesses. That is a system that is, in my view, very clearly unfair to them. Now, of course, it's difficult to avoid that happening altogether, but a system that sort of happens routinely every day to a very large extent is a system that isn't working. Of course, also, the delays that all of that causes creates enormous problems for the integrity of the trial itself. If trials, because of churning delays, take 12 months, 18 months, 2 years, or very occasionally 4 years to come to trial, memories fade. Evidence becomes unreliable, witnesses disappear, complainants lose their nerve, maybe even ultimately dismissal for abuse of process. I don't know about you, but certainly me, because I've got a very poor memory, John will vouch for that, and it gets worse as I get older. I'm appalling at remembering the detail of what happened even 6 months, 9 months ago, let alone 2 years ago. If I was asked to give evidence about something that happened 2 years ago, it would be likely to be somewhat muddled and a bit of a blur. That's routine in terms of the oral evidence that witnesses give at court. And of course, we do have mechanisms for trying to overcome that by enabling them to refresh their memory by looking at the brief of evidence that they gave to the police officer at the time. But actually, it's all a bit of a charade because we pretend that they're actually giving oral evidence on the basis of what they can actually recollect, not actually simply repeating what they read half an hour before they went into court. And of course, finally, there are significant community safety implications that result from delay in the event that the offender is actually an offender that's at risk of reoffending. So a lot of the concerns around offenders that commit offences while on bail is not actually a concern that results from the bail laws. It's actually a concern that ought to be shifted home to delays. We see it as a sort of a problem of letting people out on bail, but that's not the real problem. Now, one of those issues that I've listed there, just to stress, are issues that in my view are fundamentally about justice, not about efficiency. And therefore, because they're about justice, are issues that we need to address as a matter of urgency.